So how you doing?
Good. How's everything going with you?
So far, so good. Well, you know, typical Monday, but other than that, so far, so good.
Don't say so far so good, because then that anticipates maybe things not going great.
Well,
So you're supposed to say it's going great.
it's going great, Judge. I couldn't ask for anything more,
Yeah.
except for some amended conditions of bond.
Yeah. Well, you can always ask for more. All right. Is there a motion filed on this case?
Yes, ma'am, there is, Judge.
All right. I don't have the motion.
Sorry.
That's okay.
I've got one, but it's all written on, so you probably don't want mine.
So before I get the motion, what are you asking for?
Judge, essentially, we're asking for Mr. Doe to be able to work. He has two different job opportunities. One is at a J&J Auto Body and Repair. Essentially, there he would be giving quotes or estimates, and sanding down vehicles. And
All right, before we go on the record, Stay, are you going to have any objections?
Yes.
All right. So the court is calling. He has two cases.
I think he's on. I think he's on full house arrest, and I could be wrong about that, but I think it's just on the one case.
All right. Court is calling 2022 CR 0493, State of Texas versus Darren Does. Can I have parties announced for the record for the state?
Frank over the Reactor State.
For the
And
defense?
on behalf of Mr. Darren Doe.
All right, off the record, just one moment. All right, we're back on the record. All right, so we're here for a motion to amend bond conditions.
Correct, Your Honor. Essentially, we're asking, Mr. Doe is on bond. He's on full house arrest, GPS. Since his last release, he's completely complied with his conditions of bond. He spent a little bit of time in the Bexar County Jail, just considering his situation. I've spoken with the state and provided them with, I guess, a little bit of new information regarding this case. He was on bond on this case and then picked up a family violence assault. We had a hearing on that. And after the hearing, the state and I agreed on a bond, a rather large bond. Mr. Doe is on a substantial amount of bond right now, but he's essentially living at home with his mom. At the time of his arrest, he had a full-time job. He was doing well. He had his own apartment. Of course, he's lost those things now, but while on full house arrest, he has been seeking employment and has two different job opportunities. The first would be for JY and J Auto Body Shop, located on Culebra Road. He'd like to be able to work from 9 a.m. to 6 p.m., giving quotes, sanding vehicles, and picking up parts. The other job opportunity that he has is at a Mitsubishi dealership on San Pedro, same times from 9 a.m. to 6 p.m., Monday through Friday, selling vehicles. He's from San Antonio, has lived here his entire life, doesn't have a substantive criminal record, other than these obvious two cases, which are not good. But he has very defensible cases. Both of them are the victim in the family violence assault case that generated problems or the warrant on he was out on bond and working and doing well, and then picked up the family violence case. And I think the stress, not making excuses, but just by reasonable explanation, the stress of the murder case and the situation probably got the best of him. He got into an argument with a woman he was involved in a relationship with, and he actually called the police, and then when the police arrived, he was the one that got arrested. She immediately came to my office, and I'll let the state speak to what she's told them, but I know from my vantage point, she probably regrets and wishes that she hadn't said some of the things that she said to the police that caused him to get arrested in the family violence case, which caused him the problems on the bond on this case that he stands before you now on. Essentially, he's asking to be able to go to work, and he's asking to be able to go to religious services on Fridays at 2554 East Houston Street at a mosque, and to be able to attend religious services on Fridays from 12 noon to 3 p.m.
Okay, the religious services are going to be out.
They're going to be what?
Out.
Okay.
I mean, so with religious services, I think you can do that on Zoom or however they do it now. And in my family, everybody was always big on go to services, but if you can't make it, you can read your Bible yourself, or you can read the Quran yourself. So religious services are out. State, what is your concern about his work schedule?
Judge, just based on the nature of the offense, and the fact that, as Mr. Palpas has pointed out, he was arrested for new family violence offense while on bond for a family violence murder. Just the nature of the work itself, the obvious concern is that, fortunately, I feel like we've had a lot of people coming in who want to sell cars recently who are on bond GPS conditions. Is that work is not just at one location. There's multiple people coming in and out. Those jobs often require them to travel, not just, to their job location, but, if you're selling cars, most likely you're doing test driving and stuff. There's obvious, I think, concerns about where he is, what is he doing, is this within the nature and scope of his job? And so we are just based on the nature of the offense, the fact that he picked up another case on bond, and just the nature of the work. It's not something that we could come to an agreement on with the defense.
All right, wasn't he doing something with a banking or something beforehand?
He was, Judge.
So why isn't he not able to do something that is online again? Because that's what he was doing before. I remember him being on Zoom and he was working from his home.
He lost that job, Judge, unfortunately. And I don't want to make light. I mean, I text Mr. Villarreal on Friday, and I probably, both of his alleged offenses happened either in his house or the house of his brother. And so, the bond conditions and bond is really meant to preserve the safety of the community. And if you are,
So you're saying nobody should come over to his house?
well, that'd be impossible because he's living with somebody else.
Yeah.
So, I'm not trying to advocate against him. I'm trying to advocate for him. And I think that, when you've got a person that, and it's not this court's issue, but everyone that is going to the magistrate's office right now ends up on full house arrest GPS, or almost everyone. Even a drug dealer in the street that's dealing drugs from his house. And it's like, those are the people we ought to say, you can't go home and you need to go out and get a legitimate job and pay taxes and work like the rest of us. And so, there should be some, I guess, for lack of a better word, like logic, or, he was at his brother's house when the murder allegedly occurred, and he was at his house when the assault allegedly occurred. And so it's not like he's going out and committing crimes out in the community. And so really he's just asking for the opportunity to be able to go out and work and try to.
So I'm inclined to allow him to work, but he needs a place where, a job where that's his location. And it's not all of this movement, because at the auto body shop, you're saying it's from 9 a.m. to 6 p.m. He's going to be sanding vehicles, but then he's going to be going to this location and that location. I have an issue with all the different locations. When I have people on GPS, what I do is I start them off slowly, because once somebody's on GPS for a while, then what I've discovered ends up happening when I give them all these freedoms, they start taking advantage. Then they're going everywhere. So if he's able to find employment that doesn't require him to go to all these different locations, then the court would strongly consider allowing him to have employment while on GPS. And then if that goes well, then maybe he can have an employment that requires him to move to different locations. But he needs to get an employment where I'm at this location and my work schedule is 9 to 5. I'm not traveling here or traveling there. So bring that to me, and of course I will strongly consider it.
Fair enough.
Okay.
Well, the court, if we get a job at a specific location, and he's going to be at that location
Mhm.
from 9 to 5 or 9 to 6. And we put in the motion in the order, the contact person, the business, what he's going to be doing, the hours and the days. Will the court, and we present it to the court, will the court sign it, or will the court want to have another hearing like?
We'll have a brief hearing, but if the state agrees to that, then we won't need to have a hearing. I'll sign it.
Fair enough.
But if the state doesn't agree to it, I want them to have a chance to put on the record the reason they don't agree.
Fair enough.
Okay. Is there anything else?
I think that's from the station.
Nothing from
All right, so just bring that to the court and just let Ms. Ferguson know, and we'll put that on the docket ASAP.
All right, may I be excused?
Yes,
Thank you.
thank you. Always good seeing you.
Thank you too, Judge.
All right, court is calling 2022 CR 0493 State versus Darren Doe's. Could I have parties announced for the record for the state?
Ashley Jones for the state.
Defense.
Surgery bar for Mr. Dose.
And are you Mr. Doe's? Counsel, have you received all discovery? Did you review it with your client?
We have, Your Honor, and we have.
Court will find that the state is in compliance with discovery. Mr. Does, did you review the document titled Application for Community Supervision with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are going to proceed on count 1, which is assault, serious bodily injury, and waive count 2.
Any objection?
No objections, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge and count 1 with the offense of aggravated assault causing serious bodily injury as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am, I do.
And did you understand, Mr. Kalfas was here this morning, however, Mr. Kalfas had to leave. Do you have any objection to this attorney standing in?
No, ma'am.
All right, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1. Punishment is to be assessed at 8 years in the prison. There's a $1,500 fine. There's no application for deferred adjudication. State recommends community supervision. They're taking in consideration 2022 CR 0494. There's an affirmative finding of family violence, and there is to be no contact with NECRA, NEKRA, Doyle, DOYLE. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor, if I could make one clarification on the no contact order, it should be NECRA, NEEKRA.
All right. And so other than that, that's your understanding of the plea?
Yes, sir.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. There'll be 150 hours community service restitution, BIPP, TAP evaluation, coping with anger, and cognitive behavior course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 1, how do you plea?
No contest.
State, any evidence?
State offers States Exhibit 1 and all attachments.
No objections, Your Honor.
All right. And have you spoken with the person with the no contact order?
We have, Your Honor.
All right. You may be excused.
Thank you, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, this was a case that we had a lot of back and forth on. There were some strong defenses in this particular case, but we do believe that this agreement is in the best interest of justice. So we ask that the court respectfully that the court follow the plea agreement.
All right, are you employed?
Yes, ma'am.
What do you do?
I'm a server at a restaurant.
Do you have any children?
No, ma'am.
Do you live by yourself or with someone?
By myself.
And if you're drug tested today, what would the results be?
Next.
All right, the court will sentence you to 8 years in the prison, suspended and probated for 8 years, $1,500 fine, probated, taking consideration 2022 CR 0494, affirmative finding of family violence. There's to be no contact with NECRA, NEEKRA, Dole. There is to be 150 hours of community service restitution. This coping with anger, shouldn't the BIPP address that? Or is there something he needs more than that?
Your Honor, I do believe in this case, there was one that was family violence because of domestic relationship and one that was family violence due to a familial relationship. And so the state just wanted both courses to address each of those issues.
All right, the court is going to order the BIPP course. The court is going to order. All right, here's the thing with the coping with anger. I've read the police report. I know that there are other things that were at play in regards to this. Do you need help coping with your anger?
No, ma'am.
All right, so let me just explain something to you. If you come before me again, because the BIPP addresses anger issues, if you come before me again and it's something related to anger, we're going to have issues. You understand?
Yes, ma'am.
Ms. Abrams, this coping with anger, if he takes the BIPP course, would that address those issues? All right. And then the cognitive behavioral course. I mean, what is that, to change his way of thinking? All right, I'm going to order the cognitive behavior course. And once he completes that, 100 hours of community service restitution will be deemed satisfied, but you'll have to complete the other 150. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court to be successful?
Actually, Your Honor, if I may address that, this may be the appropriate time.
Yes.
There was Mr. Doe's, because of the cases that have been pending, had diligently been looking for employment. And currently he's working as a server, but it's been very difficult for him to find employment substantial enough to pay off the GPS fees that have accumulated in his particular case. I think he has something on the order of $10,000 in assessed fees from GPS. If the court has any ability to give some consideration on that, or to allow some portion of that to be waived, I think it would help him to be successful on this.
Oh, I have no authority to do anything with regards to the GPS because it's with a third-party contractor. So there's nothing I can do with that. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, and also because this is an affirmative finding of family violence, you're also not allowed to own or possess any weapons or ammunition. All right, probation will go over conditions with you. And once she's gone over those conditions, you are excused. To be successful in this court, communication is key. If there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can always come back to the court.
Thank you, Your Honor.
All right, thank you.
For your time, Judge.
You're welcome.
Let's get the facts straight. She loves a verbal ashtray. Never blowing smoke when she gets pissed. She's quick to castrate. Love her on a good day, love her on a bad day. Either way, she's here to stay, stay, stay. Call up holy, 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 holy.